I now want to talk about section 30 of the Act and the fault-based grounds. And there are three grounds here that really spring to mind. Firstly, ground A tenant's failure to persistently repair and maintain the property. And the court then can maintain an argument that the tenant should not be granted a new lease due to the state of the property resulting from the tenant's failure to comply with its repairing obligations. Well, the important point here is to make sure that we've got our lease and we are clear about what the lease prescribes by way of repairing obligation, and we've got evidence to confirm that the tenant is in breach. There is the potential for a sort of waiver or a estoppel argument to arise, but generally speaking, if we can show disrepair or non-compliance with covenant, we're going to get home on ground A. Ground B permits a landlord to oppose renewal if the tenant has persistently delayed in paying rent. And again, important here with regard to ground B, what the court will do is make sure that we're not simply talking about one occasion where there's been a delay in paying rent. It is a persistent breach that is established. And the landlord must have been proactive in pursuing rents as and when they remain unpaid. So where rent is paid monthly, the fact that the landlord sits back and does nothing could potentially preclude reliance on ground B. There would be an expectation that the landlord is pursuing, either via the courts or by encouraging payment, the tenant before being able to safely rely on ground B, a persistent delay in paying rent. As far as ground C is concerned, the important point here is that we are looking that there have been substantial breaches of obligations under the current lease. So these are breaches not necessarily connected with repair or non-payment of rent, but we could adopt a cumulative approach and mention non-payment of rent and disrepair along with other breaches if we wish. The beauty of these grounds is that they are fault-based grounds, and therefore a landlord does not have to compensate the tenant at the end of the term or when the application is successful. A tenant is only entitled to compensation where the landlord is relying on non-fault grounds. That is not to say that a landlord would not be liable for compensation for misrepresentation, and where appropriate, a landlord would still be liable to a tenant in connection with compensation for improvements, courtesy of Section 27 of the Landlord and Tenant Act, was the 1925, yeah.